Ever wondered if companies can legally stop you from leaving your job before a certain period? Lock-in periods in employment contracts are often questioned. But courts in India have now clarified the legality behind this. Stay tuned to find out how these contracts can affect your rights and what legal remedies are available if you feel trapped. Lock-in periods are clauses in employment contracts that prevents employees from quitting their jobs for a specific duration. Such duration clauses aim to retain talent, especially in critical roles or after providing specialized training. The big question, however, is can companies legally enforce these lock-ins? Indian courts have examined whether these clauses infringe on an employee's freedom or are fair in protecting business interests. This video will explain the legal stance, recent case laws, and what you can do if your rights have been violated. Here's a summary of what we are going to discuss. First, lock-in periods restrict employees from quitting during a defined period. 2. Reasonable clauses are enforceable, but courts will intervene if they are excessive or unfair. 3. Breach of lock-in period could lead to employees paying damages. 4. Employment freedom versus business interests. Courts balance these aspects. 5. Remedies are available if the lock-in clause is unreasonable or coercive. A lock-in clause is valid as long as it is reasonable and proportional to the business needs. Courts consider if the employer invested in employee training or provided significant perks during the contract. However, it is essential that these clauses don't exploit employees. Here are some important case laws that illustrates this discussion. First, Lily Packers Pvt Limited versus Vaishnavi Vijay Umak. The Bombay High Court ruled that a reasonable lock-in period in employment contract is valid, provided it does not excessively curtail the employee's freedom to work elsewhere. The court emphasized that clauses requiring employees to stay for a certain period are permissible when framed fairly. 2. Superintendence Co versus S.H. Krishan Murgai. In this case, the Supreme Court ruled that the restrictive clauses in employment contracts should be proportionate to protect the employee's legitimate interests without being oppressive. 3. Satyam Computer's case commentary. The dispute revolved around a lock-in period where the company sought damages for breach. Though the specific arbitration isn't available in public case law records, it aligns with the legal stance of how businesses justify such clauses through operational or financial investment. Yes, there could be consequences. If an employee breaks a clause, they might have to compensate the employer as specified in the contract. Courts, however, will look into whether the lock-in period and compensation were reasonable or punitive. Here's what you can do if you feel your rights are violated. First, file a complaint in court. If you believe the clause is unfair or coercive, you can approach the labor court or civil courts. Courts will examine if the clause was fair and proportionate to the job's requirements. 2. Negotiate with the employer. Try to negotiate an early release by discussing your reasons with the employer. Many companies are willing to waive the lock-in periods if reasonable notice or compensation is provided. 3. Approach the Labour Commissioner. If your contract violates labour laws or involves coercion, the Labour Commissioner can mediate between you and your employer to find a solution. In Lily Packers Pvt Limited versus Vaishnavi Vijay Umak, the Bombay High Court clarified that while lock-in periods are valid, they must align with employee freedom guaranteed under Article 19(1)(g) of the Constitution. This judgment has set a precedent for other courts, balancing employees' business interests and employee rights. Let's recap the points that was discussed. First, lock-in periods are enforceable if reasonable. 2. Breach can result in damages but only if the clause is fair. 3. Courts balance between protecting business interests and employees' freedom. 4. Remedies include filing a complaint, negotiating or approaching the Labour Commissioner. 5. Recent case laws like Lily Packers versus Vaishnavi Vijay Umak have clarified legal principles. Lock-in periods are not traps if framed reasonably. They serve to protect employers but must respect the employee's rights to work. Knowing your rights and remedies can help you navigate such clauses without fear. If you found this video helpful, please like, share and subscribe. Have any questions or need further guidance? Drop a comment below and we'll try to answer your queries. Take care and bye-bye.